talking about today. We're talking about a bit of a case study, and the case study is about qualifications in a pre-purchase report. Those of you who do pre-purchase reports, I would imagine that most of you will have some kind of qualification or limitation of liability or exclusion of liability clause in there, saying whether it's saying that something as simple as you haven't looked in inaccessible areas to you can't be sued for more than the cost of the report or anything similar to that. So the topic tonight is, well, does that help you? Does that help you at all? And I'll do a little short case study on a case which involved a qualification. This qualification was around you can't rely on the report if the report itself tells you to go and speak to a specialist. And that may well be the kind of qualification that you've got in your report. So let's move on. So just general sense first, in terms of qualifications, when are they effective? Well, firstly, they've got to be clear. If you can't understand them, if there's a lot of words there that don't really mean very much, or even I've seen some where there's big typos and so on, then it's not going to help you. There's lots of legislation out there, of course, that says you can't exclude certain types of liability, and probably the one that's most familiar with us is the Australian consumer law. So the Australian consumer law has various guarantees as to fitness for purpose and quality and so on. You can't exclude those, so your qualification is not going to assist you with that. It also can't be unfair. So we have the Unfair Contracts Act in New South Wales, and that essentially says, particularly when you're dealing with a consumer, none of your clauses, in particular your limitation of liability clauses, can be unfair. Now, what's unfair? That means if, for example, your clause says you can't sue me for anything, then that would be unfair because it's taking away one party's rights, creates an imbalance, and isn't really reasonably necessary to protect that party's legitimate interests. Sure, for example, you're doing a pre-purchase report, you're not getting paid a whole lot of money for it, so it would be fair to restrict your liability maybe to a certain sum. So I think probably restricting it to the cost of the report is probably unfair, but you might restrict it to $5,000 or $10,000 or your professional indemnity insurance amount or something like that. And that would be quite fair, you would think. So you got to look at your clause. And lastly, and pertinently to this case study that I've got today, it's got to apply to the claim in question. So it's pointless having, or you won't be able to rely on a clause if the clause says, well, you can't sue me for not noticing a defect in an inaccessible area under the house, if your clause only relates to inaccessible areas under the house and the issue is something that's in the roof cavity. So it's got to apply to the claim in question. So let's look at this a little more practically by looking at this case study. So this was Edwards and Froud Building Services and Hulst. Edwards and Froud were the builder, was the pre-purchase inspector. Hulst, well, they're actually two applicants. They were the owners, and what they were doing was they were looking at buying a whole building, so a block of 3 residential units. It was sight unseen, so they made it clear to the inspector, we're going to buy this without actually going there, so we're relying on you to that extent. The inspector did the report, came back pretty clean, I suppose you'd describe it. But after these guys bought it, usual thing, a couple of months or a few months go by, or even 12 months, they found waterproofing issues. I don't think there's many buildings that don't have waterproofing issues, but these guys say that it had systemic, ongoing and current water leaks that weren't highlighted in the pest and building report. they ran their case in NCAT, and they got up. I think they got about 40 grand. And the decision was based on a failure to comply with the Australian Consumer Law, Section 61 in particular, which is the one that says there's a guarantee that the services and any product arising from the services, ergo the building report, will be reasonably fit for purpose. And it's not reasonably fit for purpose if it doesn't describe or identify defects in the building. There is an exception to that, and the exception is that if the consumer didn't rely on, or it wasn't reasonable for the consumer to rely on the skill or judgment of the supplier, then the guarantee doesn't apply. And that is exactly what the inspector in this case said had happened. So why was that? So this inspection agreement that the guy was relying on, 10 pages of small print at the end describing the scope of the inspection and so on, and then another page of small print describing the limitations, so the limitation of liability. And what it said in particular was, where the report recommends another type of inspection, including any invasive inspection and report, you should have such an inspection carried out prior to the exchange of contracts. So it's clearly pre-purchase. So, and if you didn't do that, well, then the inspector gets away scot-free. Now, in this report, it identified a particular water issue in Unit 1, and it said, and the identification of it was in these terms: may become worse over, there was a photograph, by the way, said may become worse over time, period, should be monitored for any change. Further investigation required by qualified builder. So here's the clue. Talk to a qualified builder to come in and investigate. Don't rely on me. Then it said, appears to relate to past leaks in the shower, in the ensuite, or waterproofing on the rear veranda above. So our builder said, well, sorry, let me get rid of that. So our builder said, he didn't rely on me because there's a specific clause in the inspection in the report that says, if I tell you to rely on someone else, that's what you do, and if you don't, it's your bad luck. And I've said an investigation is required by a qualified builder. So what happened? Well, as we know, the owners accepted the report, but didn't pursue the recommendation to retain the expert advice of a builder. So the inspector's saying, okay, I'm out of here. You can't lay a glove on me. He argued that the failure to do so was evidence that they hadn't relied on the report, so that defence isn't available. However, what the tribunal said, and it went on appeal, so this was the appeal part of the case, they said, our reading of that part of the report, remembering it talks about the builder, but it also talks about appears to be past leaks in the waterproofing, etc., is that they weren't alerting the owners or the putative owners to a particular problem of an urgent nature. They were described as possibly becoming worse over time and requiring monitoring. And although there was a reference to getting a qualified builder to investigate, there were further qualifications to that by observations that the water penetration appeared to relate to past leaks or waterproofing. So the tribunal at first instance and on appeal held that these guys were entitled to purchase the property relying on the skill and judgment of the appellant, of the appellant builder, because there was nothing in the report that alerted them to any particular imminent problem. So nothing you need to do now, but you might need to do it further down the track. When they found when they got in, as you may recall, that there were systemic issues and lots of, well, whether they were gushing fountains, we don't know, but nonetheless, certainly something that was worse and required fairly immediate repair and not something that you just needed to monitor further down the track. So what's the moral? The moral of that story? The moral of that story is, if you've got a qualification in there, so you don't rely on my skill if I've told you to rely on someone else, is don't then go ahead and qualify that and say, but, you know, as in this case, you might not need to, or you might not need to for a while. So you need to be very careful when you are in your report. If you want to be able to rely on a limitation of reliability, don't put something in your report that's going to take you outside of that limitation. So there's the moral. So questions?
So what I take out of that is don't use the word pass.
Well, certainly not in that situation.
It's very risky.
Very risky.
Monitoring. Monitoring is no. You don't monitor things.
No, indeed. So again, you've got to be very careful in your wording. Certainly, having qualifications, limitations is worthwhile having it in your contract. And I think if you have a pre-purchase agreement that doesn't include exclusions and qualifications, I think you're looking for trouble. And they are, in the vernacular, worth the paper they're written on if you use them properly. So that's the moral.
So what would you say for monitoring?
Sorry, I didn't quite catch that. What would
you say for monitoring? How would you tell them to keep an eye on it?
Well, if you're going to say keep an eye on it, you need to be very careful that that is the extent of the problem, and that it's not something that might be required more urgently. So remember, in this case, they said there's evidence of leaks, get a qualified builder to have a look.
Okay, so classic one is the house hasn't been occupied for 2 months.
Yep.
You go, how are you going to do a waterproofing test?
You don't.
So you don't. So what I say is doing a quick waterproofing test, it's not going to work. Monitor after the shower recess has been in constant use. So does that open me up or what?
Well, if it was reasonable for you to say, well, I can't tell at the moment.
Yeah.
And then that's fine. That's not a problem. But in these guys' cases, it wasn't reasonable to say, well, I can see a leak. I can see evidence of a leak, but I don't know anything more about it. So go and get a qualified builder, but all it needs is monitoring when that isn't what it needed. So they should have done more investigation. Or they should have said, if they weren't sure, they shouldn't have said anything about monitoring. They should have said, there's evidence of a leak. It needs to be investigated more closely by a qualified builder, full stop.
Yeah. So do you have to put, like, prior to purchase, for example, like if it's a pre-purchase, would you say investigate it further prior to purchase, or do you give them a time frame?
Well, these guys in their exclusion actually said before exchanging contracts.
Yeah. So they tick that box.
So they ticked that box, but they missed another box.
So, David, what about corrosion? Like, corroded fixings in decks and balconies, and that's when you will maybe say to monitor, regularly, even though you're quite fine, but there's degrees of corrosion. So, sometimes you sort of need to say keep an eye on this in the future.
And cracks and things like that.
Yeah.
So be reasonably sure of yourself, I suppose.
Yeah, well, that's right, and err on the side of caution. So, if to your experienced eye, there's a little bit of corrosion, and to you it indicates, and to a reasonable inspector applying due care and skill, it indicates that there's not a problem at the moment, but it might be a problem in the future, then by all means, identify it and say monitor it because it could result in X, Y, Z, whatever it might result in. But if you think that it might be anything more than a minimal amount of corrosion, then I would be saying there is evidence of corrosion. That corrosion could indicate whatever, structural issues or concrete cancer or something, and leave it at that. And if to tell whether or not there is actually a significant issue, there needs to be some other investigation, then say this is what needs to be looked at. And then full stop. Don't say and monitor it or do it down the track or talk to someone later. Stop there.